say it's too late. I am a pro bono with Legal Aid Center of Southern Nevada, and I've incurred over $200,000 in attorney's fees on this case. So we're not really concerned about that anymore.
$200,000?
Yes, Your Honor.
Really?
Yes. Really?
So this is all based,
It does.
Ochoa left a year ago. You're saying Parlati recused, and now O'Connell has recused. Case cold.
I assure you, I
Okay,
know the
okay.
procedure and chronology like the back of my hand.
Perfect. Okay, proceed, please.
It's my earnest belief that you are a good judge, and I'm happy to have you hear the matter.
You're pretending not to understand my question.
What?
I
John,
personally
heard
think
you.
it's sad that you put pride and wanting to be right ahead of you actually having a relationship. Because kind of we're stuck with what happens. People who are represented as being good judges then are sometimes classified as very poor judges once there's an adverse ruling, and I don't want to deal with a disqualification down the road if there's a basis to do so now. But let's be intellectually honest. You just don't want to, and you never did want to, and I'm angry because you blew his chance to have you as a father the last 5 years because you want to be right and you don't want to comply with court orders that you disagree with, and you're trying to make it seem more complex or multi-layered than that. You have 31 years experience. You know in this case you're not going to keep bumping judges, that you won't be able to recuse enough judges to finally find one who says, oh, I don't care that Dad didn't comply with any supervised or reunification put in place when the boys came. Blaming her, blaming attorneys, and blaming the system when all you needed to do was follow a court order 5 years ago. Stop,
5 years
Mr.
I've been
Phillips,
litigating.
stop pretending to misunderstand. You may disagree. You disagree with my view, but don't pretend that you don't understand it. You had a 12-year-old that you haven't seen. He's almost now 18, and it's your doing.
I just think, Your Honor, respectfully, for you to blame me is shocking. I have no idea what somebody's told you or not told you.
No,
the point is,
I state for the record, I don't discuss my cases with other judges. You obviously are convinced that goes on, and that's probably what's best for him. So you don't care what's best. You don't care what's best for him. You just want what you want. We're going to call Phillips matter D. Appearances, please.
Ms. Wilson, are you able to hear the court? We wanted to call your case.
Not hearing me?
Oh, we got you now. Perfect. I think we're good to go, Judge.
Okay. Very good. I'm sorry, where's Shannon? Oh, Ms. Wilson, you're on the, are you present?
Yes, can you hear me?
Yes, is at the table or anything? No?
She is not. This is purely procedural, Your Honor.
Oh, sure, of course. And is Mr. Phillips there?
good morning, Judge.
Good morning.
I'm here.
Excellent. I have to just be candid and tell you, just this very second, I learned there's I'm not sure I can rule on anything today till I get over this. There's a request to disqualify judge. It seems to be discussing Judge Ochoa more than anything else, so I'm sort of at a loss as to what it, but it is a recent filing. It's 9/11. I don't know. I could check, see if someone has a status on it. I could check the record here, see if the presiding judge has ruled on this. Or Ms. Wilson, you know anything about this?
9/11, Your Honor. Give me a moment. I don't think I'm familiar.
It should be an Odyssey filed on 9/11, a request to recuse judge. I don't really. I could reread it. It seemed to discuss Judge Ochoa and a lot more than it discussed this court. So I'm not 100% sure what's going on. But let's see if there's some sort of. I'm going to see if there's some sort of update or ruling on it.
Your Honor?
Yes.
This is respondent, and if I may politely ask a question, can you please tell us who filed this motion and what is the name of the motion?
The current motion is filed by you to set aside the order, I believe, and the last order. But I see that there's also this affidavit to disqualify judge. This is your motion we're here for today. Motion to vacate the notice of order.
Your Honor?
Yes.
Let me give you the procedural history that I understand
Okay.
we're operating under today, and Mr. Phillips can let me know if he has a different understanding of where we are. So we had a hearing on August the 15th before Judge Parlade.
Your Honor, may I interrupt, please?
Well, let her finish, but I am seeing that it does appear there was an order, 913, to disqualify somebody. If it's,
I believe that was
let me see who it is. If it's disqualifying this court, then of course I'm not proceeding. If it looks like it's an
Gina McConnell.
Well, hold on. It appears that it disqualifies Judge Ochoa based on some political situation. Let me see. Department O, that would be him, I guess, is disqualified. So it looks like his, which is quite candidly is seldom the case, but most disqualification attempts are not successful. But this one was. The judge, chief judge, ruled on it on the 13th, and I have it here. I don't know if I assume you guys received it. Ms. Wilson, did you receive and read Judge Weiss's order?
So
in 2 days
what you're looking at, I
think, by
think,
Mr. Phillips to disqualify the judge. Judge Weiss agreed with Mr. Phillips and issued a disqualification order, and that's where we're at. But Mr. Phillips seemed to not be aware of why we're here today, but it's his motion to set aside the last order, so I was hoping that he's aware of his order, his own motion.
I am, Your Honor.
Okay.
I am.
Your Honor, would you please allow me to catch you up on the procedural history of the disqualifications? Mr. Phillips, I assure you I'm not going to say anything.
You can, but does that mean you heard nothing of what I said, which seemed to be that I'm instructing myself based on what I see here, that a disqualification did occur on the 13th. So if you need to bring me up to date on that, it means I might have not been heard, maybe because of the audio. I'm indicating that I'm aware. If you want to add important details, that's great, but am I incorrect that this disqualification occurred?
The disqualification that you're talking about occurred a year ago. Judge Ochoa's disqualification.
No, it says 9/13/23, and his affidavit
That's
to disqualify was 9/11/23, and this disqualification order is 9/13/23, not 22. Maybe he filed two of them. I don't know. A year apart. I just don't know. So bring me up to date then, because this one is very recent, and it might have been that he disqualified another judge a year ago. I don't know. Let me look.
It did. Your Honor, could you please
It's Gina McConnell. Can somebody say Gina McConnell?
She's mentioned in the Judge Ochoa order. Let me look to see if a year ago there was another disqualification, or
Judge, if you will hear me through, you will come up to speed very quickly.
You're telling me you're going to get me up to speed, and you seem when I'm trying to review something recent, you're trying to say, ignore it. You seemed oblivious to the fact that this is a very recent additional disqualification. So if we're going to instruct...
There are multiple disqualifications in this case, Your Honor.
Let's make sure that who's ever bringing me up to date knows the procedure and the chronology of this case cold.
I assure you, I know the procedure and chronology like the back of my hand.
Perfect. Okay, proceed, please.
All right. So Judge Ochoa was disqualified over a year ago. In that span of time, there were multiple other disqualifications until finally Judge Parlade heard motions on August the 15th. after she heard motions on August the 15th, Mr. Phillips sought her disqualification. She filed her own order recusing herself on September the 5th.
Yeah. Mm-hmm.
Thereafter, Regina O'Connell was reassigned the case.
Well, let me interject.
And then Ms. McConnell disqualified
show a
herself.
disqualification order filed a year after the disqualification occurred? Or are you suggesting that it's his replacement that, well...
So, Your Honor, I'm looking at Odyssey, I'm looking at September 11, 2023, and the only thing I see filed on September 11, 2023 is an affidavit in support of a request for disqualification.
Okay.
That's all I see on September the 11th.
And then you see on October, the October, where is it? No, I'm sorry, 9/13. 2 days later, Judge Weiss issued the disqualification order. And let me take a look at it more closely. It does seem to be focused on Judge Ochoa, Department O. So if he had been dumped from the case a year ago and other judges got involved and subsequently disqualified, why would this order be issued a year later? It's right there, see it?
So the order that is filed on that date is signed by Judge O'Connell.
Yeah, O'Connell.
September 13, 2023
Oh,
is
okay.
the order
Yes,
of...
yes, you're correct. It was set up to look like an order for disqualification as opposed to a voluntary recusal via minute entry. It's set up to look like a chief judge order. So this is all based...
It does.
Ochoa left a year ago. You're saying Parlati recused and now O'Connell has recused.
Correct.
Oh. Yeah, if you want to save me some time giving me the history, tell me why, because if somehow we got 3 or 4 judges in a row who have some sort of conflict, I don't want this to be a fool's errand and push up your attorney fees or his attorney fees if he secures an attorney with a farcical thing where every time we don't like an order, we're dumping the judge. So if there's a basis, if this court is somehow tainted the same way these other judges are for whatever reason, that's a dialogue we would need to hear about now, I think.
So, A, it's too late. I'm a pro bono with Legal Aid Center of Southern Nevada, and I've incurred over $200,000 in attorney's fees on this case.
This
So
is
we're not really
$200,000?
concerned about that anymore.
$200,000?
Yes, Your Honor.
Really?
Yes, really. But we don't need to go into all of that. What we need to do is exactly what you put your finger on, and that is to hear whether or not Mr. Phillips thinks he has any basis for your disqualification, and if he does not, then we can proceed.
Correct.
Judge, may I be heard?
Well, actually, when people say "may I be heard," after the attorney framed the exact pointed question that needs to be addressed before people start telling a story, "may I be heard" means we didn't hear what was just said. First, you have to answer that, because don't argue a case to me if there's a basis for this court to disqualify, and as the attorney just indicated, let's get over that hurdle first.
Well, Your Honor, I've been licensed to practice law for 31 years, and I've done thousands and thousands of law and motion practice. I'm licensed in the Ninth Circuit and also the U.S. Court of Appeals.
This is deflection or a distraction. We don't need to argue that. What if I just concede that you're a highly experienced, skilled lawyer? I don't believe I was debating or questioning that. I want to know, unless you guys want me to take a deep dive and read all these recusals, which I can do. Miss Wilson brought me up to, and I apologized to her because I was under the impression that you guys weren't noticing a recent recusal order by Chief Judge Weiss, but it was, as she mentioned, from Judge O'Connell, which cleared up my confusion, and I'm sorry about that for being a bit grumpy on that, because I got thrown off because I said here's a recent disqualification order apparently from a chief judge that no one's alluding to. So, Mr. Phillips, before you get to your motion to vacate, let's deal with this. And
Okay.
you don't respond to it by telling me your experience and your reputation.
That's
Let's
fine.
just assume I understand that and
There's
agree
no-
with.
no
Let's say
allegations
I
of
understand.
disqualification.
Hold on. Let's say I understand and agree with that. What is
Okay.
this? Do we have some sort of disqualification issues relative to this department? Because it seems that there's
None.
a common thread going through here. So go ahead.
Well, I think there is a common thread with the other judges. There is no disqualification motion from my office. I have never sought disqualification against Your Honor. I am anxious to proceed with Your Honor. I believe that you're a good judge. I say that sincerely. I've watched your videos on YouTube. I would just ask to have my day in court here. The other disqualifications up to present time, I think those former disqualifications are irrelevant. They are manifestly irrelevant to anything that may be heard today.
Well, I'm so
unless
sorry.
you are-
I'm so sorry, but I think it would be buffoonish of me not to make this inquiry when literally 3 judges have fallen off the vine within the last year, which is highly unusual.
Okay,
so
I can tell you all.
forgive me for trying to be thorough to protect your rights in the event you have something legitimate. If you're agreeing it's irrelevant, we can just proceed on the merits, and that's fine. Let's proceed.
Unless Your Honor has some disclosure, and I don't mean to be impertinent, but if Your Honor has knowledge of me outside of court, I would ask only that, respectfully, that Your Honor disclose as much.
The only disclosure would be if if you want me to take a moment and review everything that caused Ochoa, McConnell, and Parladay to recuse, and if somehow I see some commonality there, then that would be the disclosure. But independent of that, not having done a deep dive on that, I don't have anything that comes to mind. But if you want me to take a quick gander at all 3.
I would prefer to proceed on the merits.
Okay.
It's my earnest belief that you are a good judge, and I'm happy to have you hear the matter.
Well, you know why I'm doing it, because kind of we're stuck with what happens. People who are represented as being good judges then are sometimes classified as very poor judges once there's an adverse ruling, and I don't want to deal with a disqualification down the road if there's a basis to do so now. But yeah, let's not beat the dead horse anymore. If you have nothing further to say on that, let's dive into the merits. So
If I could be heard on the motion, Your Honor, just
that's
to
what I'm
save
saying, but
time.
let's proceed on the motion, please.
I believe it's moot because the order had sought performance in the past. In the date for which performance was sought, that date has elapsed.
Okay.
And I think that it's fair to say the motion is now moot. That having been said, I would like to talk to Your Honor for a moment, if I may. With the court's permission, I would like to make an oral motion to allow me to see my son. I have not seen my son in 5 years, and there was a TPO that was issued 5 years ago, but there's absolutely no evidence of any domestic violence. She alleges it, but the truth is there's no evidence. I never violated the
Let me
order.
ask you-
I've
let me
had
ask you this.
zero.
Obviously, if you have a 17-year-old who you haven't seen since age 12, there's a gazillion questions. Does he want to visit you? Is he uncomfortable? Do they dispute your representations that there haven't been these problems? Do we have reason to believe that any reintegration on your part should probably be in a reunification or therapeutic realm? And more to the point, the comments I just made more apply to children 12, 13, and 14. We're getting to a point, if he's turning 18, he's going to be outside of the jurisdiction of the court within a few short weeks. Anyway, I guess one could argue if he remains under the jurisdiction of the court for child support purposes till he graduates in May, if that's when he's graduating, that he'd remain under the jurisdiction of the court for visitation purposes. But I think this is something you have to kind of deal with your son when he's of age, because unless I'm wrong that he was born in 05, as a practical matter, as a hyper-technical legal matter, I guess we have a few weeks, but these are what do you hope to obtain here?
Your Honor, let me be very specific. There is a court order for reunification,
Okay.
and Shannon Wilson is a hardcore advocate, just like all the judges are, to send me to the reunification camp.
Mm-hmm.
However, I know of no statutory obligation to do reunification. My son was stolen from me immediately. There was no integration and he was taken. If I don't see him now, he's been
seen. Point. Best interest of children is very, very broad. It's not a matter of if someone hasn't seen a child in a long time, it's not a matter of, unless someone can quote a statute or case preventing it, that anyone can just go and re-enter the life of a child where there may be serious issues. How do you know so the very, very broad discretion simply under the best interest standard. So you haven't answered my question. Do you think and I understand if he doesn't want to see you, you may be saying the cause of that is largely mom, but why is it he hasn't seen you in 5 years?
Well,
tell me something constructive without just blaming the other side. More importantly, do you know whether I wouldn't ask if he was 10 or 12 necessarily, but he's 17, he's going to be 18 in a month, how he feels about this. Why can't you simply wait till he's 18 in November or graduates in May if he's in 12th grade? And deal with it then. It just doesn't seem to make sense.
Your Honor, if I may be heard, and again, I don't mean to sound disrespectful, but I would ask the court.
You're a skilled attorney, and you need to answer questions directly. You don't, as you know, you should invite, like particularly if you've ever argued before appellate courts, the focus should never be on shut up justices, let me just tell my story. When they interject, view those as opportunities. If you say, just let me present, it's like saying, I don't care about what you just said. This is a critical control dialogue. This isn't a conversation where reasonably everyone gets to say what they want to say. And because I interject a lot, that might be viewed as unpleasant or uncivil, but this isn't a conversation with your friends. So if you just tell me that the question I asked, which is just about everything to me, because if we had a child this age chomping at the bit to see you, and the sole impediment to that is mom doesn't want it, so you should welcome the opportunity to answer this question, which in all likelihood is 10,000 times more persuasive than some historic backstory you're going to tell me. We have a child who's going to be out of the jurisdiction of the court awfully soon. Do you have any understanding, comprehension, insight, or do you even care about how he may be predisposed to this at this time, whether he is ready to jump into the deep end of the pool or whether he wants to take it gradually, a situation which you may have not availed yourself of the reunification. So I want the question answered directly because I'm required to inquire like that. So tell me about what you know or don't know about the current situation and whether he's comfortable and whether he wants this.
Your Honor, I have no idea. I have no personal knowledge of any kind whatsoever because I have not heard his voice in 5 years. There's an order that allows me to make phone calls, but without blaming the other side too much, I've not had one phone call in 5 years. I made an OSC to force the phone calls, but the matter was taken off calendar, and I have no idea. The only thing I know is my son has not spoken to anybody with the last name Phillips in 5 years. The other side has gerrymandered it, so she alone is the sole blood relative for the minor child.
Please address their representation, and you should be delighted to address this if it's at all false or misleading.
I have no idea, Your Honor, because I haven't spoken to you.
Okay, you answered my first question, and that's good, thank you, but you need, for your own interest, answer the second one, and you should be eager to answer it if you're indicating that they're engaging in subterfuge. If there's been a structure for reunification, which apparently there has been, have you adequately availed yourself of that to any extent, or did you not participate?
No, Your Honor, and let me explain. I have not availed myself.
Okay.
I have no intention because it's a prison-like setting, and I do not want my son to go through armed guards in metal detectors to see me because I am an honest, decent, and forthright individual who's never done anything criminal. And I believe this court for 5 years has done everything to criminalize me, but I refuse to.
I'm just a brand new entry to the case, but that aside, are you, is this figurative, illustrative speech, or this, I assume this is just metaphors or whatever, or are you literally indicating that there's some sort of, what do you mean about, I'm assuming this is symbolic, dramatic imagery, and that you're not incarcerated, obviously you're not. So what did you mean about the last remarks?
About the criminal matters?
About
I
that
could
he
be-
has to go
yes.
through armed guards and metal gates to say hello to you.
Yes, because that's because Donna's house is located inside the courthouse. In order to get to Donna's house, the children need to go through armed guards and metal detectors.
Okay.
And I think that's
Not
inappropriate.
any worse than at the airport. You understand that's a bit over dramatized. So, Mr. Phillips, let me cut right to the chase here. And I would appreciate your direct honesty, and I think you already answered it. Because you disagree with these orders, you resisted them for 5 years, while arguably you could have normalized your relationship with your son, but because you don't want to file orders because you don't think you should, then why is it even, why do you bring it as an attorney into a legal arena if you're signaling to us you're only going to comply with the orders you like? They
wouldn't even let me make phone calls. I can't even get a phone call. If I were to tell Shannon Wilson...
I get that, and let's assume that that's true and that she plays a significant role without that cooperating on the phone call. Let's just assume it. Do I understand that for 5 years, and this case is a 2018 case, are you saying for 5 years since is 12, there's been various models in place for you to reunify or visit, and in order for you to then normalize your relationship, something which maybe could have happened within just a few weeks or a few months if you had played ball, you're saying because you don't think you should have to, that you didn't comply?
Your Honor, my relation with my son has always been normal. There's no statutory requirement to go to...
You're pretending not to understand my question.
What?
I'm having very little tolerance here for this dialogue.
I'm sorry.
Because you are a skilled attorney with 31 years practice. Please don't engage in the pretense that you don't understand. Saying my relationship's always been normal when you just told me you haven't seen him for 5 years is a farcical statement. These questions are designed to help you and your son if there is a basis for this. Do I understand? And if you don't want to answer the questions, Ms. Wilson is going to be more than happy, and I doubt that you want her to be the sole source of information I receive. So is it my understanding that you've had a supervised visitation model in effect, or a reunification model that you could have complied with, and now you would be seeing your son, what I mean on a normalized basis, unsupervised, overnights, etc. But you didn't comply with that because you disagreed with it and you felt you didn't have to?
Well, that, plus also that I believe if I made an appointment, they would never bring the child. They can't even get him for a phone call.
Why didn't you set a trap for them and show up?
I tried to.
Why didn't you show up at the appointment and then there's documentation that they didn't appear?
Your Honor, the point is
will be the point
I don't
that
want
the court is required to make the point. I need to know, and if you want to add information, that's fine, but I think you've answered it. And if you don't want to answer it more directly, Ms. Wilson will. I think, and with the qualifier in place, I may have different questions or a different perspective when I do a deeper dive on the whole case. I just inherited this case like right now. I admittedly wasn't even aware of the current status of all these recusals. So with those big qualifiers in place, which might change my perspective to some extent. I'm going by what you told me, that you haven't seen your 17-year-old since he was 12, and in large part because you don't believe, and let's assume you were right and that you maybe shouldn't have been required. But just to get that out of the way, you're saying you didn't comply because you felt, A, you didn't have to, and B, she wasn't going to produce. Is that what you're telling me in a nutshell?
Well, in a nutshell, but
Okay.
if I could add to that, let me add, please. It's not merely because I'm whimsically opposed to it, because I have actual knowledge there's no statutory requirement. Just, I think it would be futile.
We handled that already, and you're free to run an appeal or writ, do whatever you want, in which time he'll probably be 20 by the time it's resolved. I already told you, and I'm sure these other judges have told you and made sufficient findings that under best interest and there's going to be no specific statute or case law that may analogize or be on all fours with your factual situation. But I think what I'm looking at in the various filings and orders of these cases, the statutes and case authority have historically more than justified this. I don't think if you're suggesting that an appellate court would say, because someone didn't sufficiently quote statutes or case authorities and analogize them directly with the facts of this case, the courts never have the right to restrict a father or a mother regardless of the circumstances or how long they've been gone, and that's absurd. As you know, these are largely as you know, in this area occasionally there's intriguing questions of law, but 85 or 90% of the time these are largely factually driven cases against a very general, undisputed legal backdrop of quote-unquote best interest. Once in a while there's an interesting legal issue. As you already know, this is a fact-driven matter, like most of these matters are, and they're generally under the pale of some very, shall we say, generic, general legal concepts of best interest, change of circumstances, etc. So if the point I'm making is I think this is a more of a behavioral or psychological issue, because let me put it this way. If I was in your position, and I try and put myself into people's position, I would say maybe I don't like these orders, but I'll jump through the hoops that I need to. But if you just say I don't want to because I don't think I have to, I mean, you pay taxes that maybe you don't think you should have to. We pay licensing fees and a million things that we don't think we have to. But in this realm, because, never mind. I personally think it's sad that you put pride and wanting to be right ahead of you actually having a relationship. Because why should I have to? Why should I have to? I would have said, yeah, if I was in your position, I might have said, why should I have to? But then I quickly would have answered it myself. But I do. And the judge already told me that do a few visits over a few weeks, and we don't have to worry about this anymore. Translation, you could have solved your problem probably 4 or 5 years ago with just some semblance of compliance. And the more I'm looking through the history of this case as we speak, the more I'm convinced that this was a point of pride on your part. You don't have the insight to understand that you just want to be right. You want to be right in this fight. And I think it's sad because I do think you do historically when you with your son. I think you seem very sincere, that you love your son very much and do sincerely want a relationship, but you don't have the insight to understand that that point has become a secondary, a distant second to just you have to be right. Now,
it's not about being right.
Let's say you are right. What if you wind up with some appellate order saying you're right, and by then your child is 22 and you can't do a darn thing if he doesn't want to see you? Is it about being right? And because the fact of the matter is no judges have, and even less tolerance for attorneys who keep saying, I don't want to, I don't want to, I don't want to, because I don't think I should have to. I'm sure these judges have quoted 1,000 times for you what statutes or case authority control best interest, and I'm sure it didn't matter what they told you because there was no citation they could have offered you where you would have said, oh yeah, now I reviewed that, now I get it, now I'm going to cooperate. Let's be intellectually honest. You just don't want to, and you never did want to, and I'm angry because you blew his chance to have you as a father the last 5 years because you want to be right and you don't want to comply with court orders that you disagree with, and you're trying to make it seem more complex or multi-layered than that, and I don't think it is. So now what do you really want done now that he's going to be 18? What do you want this
I would
court to
ask
do?
I would ask Your Honor to take judicial notice of the case of Roe versus Roe,
I'm
a recent
well aware of
appellate
it. I'd
decision.
be happy to take judicial notice of all
Okay.
the cases. I'm
In that
asking
case-
you can ask me to take judicial notice of any Nevada Supreme Court or appellate court decision in this area, and I'd be happy to do it. That doesn't mean the court is necessarily saying it controls these or those facts. You know that you understand the question. The question is, you're answering me, no, I want to be right. I want to argue the law and statutes, and this shouldn't have been these roadblocks shouldn't have been in my way for 5 years. I'm asking you a question. If you are a concerned parent and the hourglass is running out, what do you want the court to do vis-a-vis your son? And if you keep telling me something that you've probably been arguing for 5 years, I want the court to take notice of this or that. Do you want a relationship with your son or not? Or do you want to
Yes,
just
I
argue
do,
and
Your
be
Honor.
right?
I was laying a foundation.
Well,
What I want the
I
court to
want a
do.
direct answer because we have just a few weeks till he's 18. What do you want done?
I would like to have the court issue an order allowing me to see my son this weekend.
Okay,
Have
now
him
how
bring
do I
over
do
for a
that?
day.
How do I do that if for 5 years you haven't complied with prior court orders that I'm bound to, whereby you don't just change judges and change the existing orders, the stare decisis, etc. It's res judicata. How do I just say, oh, I don't care that some judge 5 years ago ordered supervised or reintegrated visits. 5 years have now passed. I'm just going to ignore that. How do I know how your son is going to react? How do I know it wouldn't traumatize or upset him? How do I know any of this?
You can, Your Honor,
I think you're a highly intelligent person that can't see the forest for the trees because you're letting your emotions and ego and wanting to be right get in the way. I can't issue that kind of order, and you know that. A 12-year-old and you were given the right to reunify or supervise visits, you didn't exercise it. It's even more critical now, 5 years later. Okay? I mean, okay, fine. You don't want to answer the obvious. Go ahead. Just go ahead. It's upsetting.
Your Honor, I've answered.
Because I'm not upset at you because the way you're arguing this, per se. I'm upset at what you did to yourself and your relationship and your ability to be there during later teens. I'm upset what you did to yourself as a father because you're a fine lawyer and probably a very good person who just fell into a common human failing, which is you let ego and the desire to be right get in the way. And at some point over the last 5 years, I was hoping you would have taken stock and had the insight. So it's a shame. There's $200,000 that could have been built on the other side. I'm mentioning that to give a concept of 5 years, many hours, and just because a case is complex in terms of time spent, contention level, attorney fees, it doesn't mean the basic concept that caused all that is complex. And it looks like it may be you wanted to see your son on terms that you demand, and you weren't going to comply with these orders because you didn't feel you had to. And what I'm telling you is, even if I assume that, if I look back, let's say I would have agreed with you on some of these things. What difference does it make if 5 years ago I would have agreed with you? I didn't agree with orders when I was practicing, and I just told my client, you better comply with it till we can do something better. So I can't just tell, unless Miss Wilson says he wants to see you, or Mom says that, or some of that, or if I have a report from a therapist or counselor that says he's sick to death, he hasn't been able to see Dad, and he's all this litigation, even though you haven't complied apparently for 5 years, if I was presented with something that says is sick of this, he hasn't been able to see Dad because of the court proceeding or Dad's supposed non-compliance with orders, but he really wants to see Dad, you know what? That would cause me to say I don't really care that much what was ordered 5 years ago, because here's the new changing dynamic which nullifies all of that. We don't need all of that if we have a 17-year-old who has a level-headed, sincere preference to see his dad. We don't have to go back in the time machine then, but no one, you don't want to tell me. Miss Wilson will probably be happy to tell me. I'll tell you what, I'm gonna go to Miss Wilson, then we'll come back to you. And you'll see me
As long
cut
as
her off just
keep
as
the record.
firmly if she wants to and she's not going to, but trust me, if she meanders into areas that are not germane, and if she somehow doesn't want to tell me how predisposed at this time, I'll redirect her just as well. I don't think we're going to have that problem. Ms. Wilson, you heard all of the court's focus and concerns, and that I'm in a wicked mood on this matter because I think what Dad's deprived himself and his son of. What observations do you want to make?
The child has a telephone, child has access to email. The orders say that the child can reach out to Dad anytime he wants to. My client has told me repeatedly over the years that she, from time to time, encourages call his
You'll
father,
say,
call his grandfather.
Please, this is a please, okay?
She's testifying.
Presenting, okay? This isn't testimonial evidence. Let's go ahead. Go ahead. I understand its argument. So proceed, please.
Right. Mom has from time to time encouraged the child to reach out to Dad, to reach out to his grandfather, and the child can do that anytime he wishes, and as Mr. Phillips is telling us, he's not heard from his son, the child has not chosen to do that.
Anything further, Ms. Wilson?
Not unless you have a direct question, Your Honor.
I guess my direct question is, what order should emanate from today? And I can't think of any new proactive orders per se. As you suggest, we have a child who's going to be 18 soon. And Dad, you and him have the right to speak to each other. And if you're saying Mom is controlling it, I mean, maybe if it's a 8, 10, 12-year-old, but I doubt a soon-to-be 18-year-old who really wants to speak to a parent and has his own cell phone is...
It's 5 years of brainwashing.
You can talk, when did you last try and call him?
Your Honor, the phone goes directly to voicemail.
Okay.
He hasn't returned any text message. There's been literally zero communication.
Does he have does he have his own phone?
He may have another phone. The point is, I send him gifts and I can't even get him to corroborate. He has his own phone, but that's what they tell me. I don't have any personal knowledge. I'm going on what Shannon Wilson says, and she's not always a straight arrow.
You had the keys of freedom on this case, and now I'm upset because, number one, what you've done to yourself and your son that you conveniently want to blame on exterior people or circumstances, and number two, I'm upset that even if I had all this drama, that he was still, and all this delay of 5 years, but he was 12, 14, 15, I could do something constructively about it, but what? Well, is he graduating in May? Is he in the 12th grade? Or did he graduate?
I have no idea.
Because he turned 18, he's turning 18 in November, so it could be either way. He could have graduated this last May, or does anyone know?
Dad has access to the child's school records, so he could have this information if he chose to access.
I wasn't really interested in the grades per se or anything like. I just want to know. The reason I'm asking, which I telegraphed earlier, is obviously one could argue. It's not much of an argument, but one could argue by extension that if the court retains jurisdiction over an 18-year-old for another 6 or 7 months till they graduate high school as to support, could that also bleed over into retaining jurisdiction for visitation and other concerns? So it's probably not much we can do about it, but arguably, if he did graduate already, we don't even have to argue that point, because then I only have another 2 or 3 weeks to deal with. 2 weeks till November 8th. So do either of you know if he graduated in May or whether he's going to graduate this coming May?
He will graduate in May.
Okay. Okay,
Your Honor?
yes.
Is there some way, is there some order that you can fashion today to allow me to communicate in some fashion with my son so I know it's him?
Yes,
Because
but
there's
yes, but,
only
and there's,
have that
yes,
order.
yes, and the orders already exist, but that's not, you know that the piece of paper is not the issue. The issue is effectuating it in reality, and it's almost impossible to pin a contempt on someone who is custody of a 16, 17-year-old, and to blame them for blocking things. If you had the keys to the cell for 5 years, you could have solved your problem with
I
the
haven't had
supervised
the keys. That's not
reunification.
true.
I can't. You're not going to be able to effectively, as a practical matter, somehow blame this on the other side, unless, again, you could prove, which would seem borderline absurd, but I suppose it's possible, that he's really, really wants to see you, in which case he would have contacted you, but mom's solely blocking it somehow, even with a 17, soon-to-be 18-year-old.
Been brainwashed.
So you
He's
already
been
have the
brainwashed.
orders in effect. Instead of looking at this from the backdrop of a certain order at this point is not going to correct this profoundly complex, long-brewing problem. I could issue anything today. I could issue an order saying to change his perspective. He needs to visit Dad. It's not going to have any effect on the circuit in his brain and the emotions involved. So, what order do you think would cause him to contact you and be delighted speaking with you and visiting with you? Is there such an order?
Yeah, I believe Your Honor can simply enforce the order. Your Honor's made a big to-do about the order where I have to do reunification.
Yep.
They're required to make the son available, and
Okay.
it's
But
never
again,
made the
we're
minor
not going
child
to
available.
continue to go in circular, nonsensical directions. You can't tell.
It's not
You may
so.
be right, but you can't tell me someone wouldn't have produced him for a supervised visit if you didn't bother showing up for it. You're an attorney and you know that. Even if in your heart of hearts you knew she wouldn't, and maybe you're right, you can't engage in that type of analysis. I already told you over and over.
I
You
have a
know it.
solution.
You have 31 years experience. You know in this case, you're not going to keep bumping judges. That you won't be able to recuse enough judges to finally find one who says, oh, I don't care that Dad didn't comply with any supervised or reunification put in place when the boys
Yeah.
called. I'm just going to order that even no matter what's going on, no matter what wants or doesn't want, that Dad is empowered with an order to go and pick him up. And then even if you had such an order, he's not going to go, and the police are not going to get involved in it. So what is it that you want to see happen? Maybe instead of looking at this as a legal case, did you think of sending him? Did you ever at any time the last 5 years or the last few years send him let's say an email, an extensive, heartfelt email that says, "I don't want to."
Yes.
Hold on.
Yes.
As follows: I don't want to talk about the case. I'm not looking to blame your mom for anything. Trust me, don't want to put you in the middle of anything. I just love you, and I want to have some sort of relationship with her. I want to know about your school, your friends, your life, your concerns, your problems. And just something that heartfelt and simple. Did you ever send anything like that?
Of course I did, Your Honor, on many occasions. The point is that I believe he's been so brainwashed.
Okay.
It's just unnatural. He just doesn't. He must think
you
that
already know
I
the
don't
answer
love
to
him.
that. Yeah, I can't do anything about it anymore.
Yeah,
Okay.
Your Honor,
Had
I
you,
do
sh-
want to say
had you
something.
shown up for the supervised visits and she didn't, or it was conducted in a way where he was resistant, I would have had a report, or the prior judge would have had a report that would have led them to believe that mom's had an undue influence. Then we could have gone in another direction with a specialist or the court to interview him. And if there was no money for the specialist, the court could have interviewed him. We could have handled all that if you had just complied
I have
with
an
orders.
idea. What if we do this? What if Your Honor orders all the parties on Friday, October 27th to go to Donna's house, and I'll submit to the court's authority, and I can see my son on Friday, October 27th. And let's see if court produced the minor child. Let's test them like Your Honor
Here's
suggests.
the problem. That could have been a good test some years ago. Now, let's say they fail the test, they don't produce him, and then by the time we're back in court complaining about it, he's 18. What can I do at that point?
I guess we'll just let Shannon Wilson keep filing motions, I guess. I don't know
Well,
at this
you
point.
filed it.
But I believe Your Honor said, Your Honor has been very critical of me, I think almost unfairly so, about this Donna's house.
Yeah, you're correct. I'm not critical of you or your love for your child or your actual initial motivations. I'm highly critical of the way it's been warped and twisted and rationalized, and you don't seem to be aware or have the insight to understand that you got so caught up in the battle and being right that you just let time slip through your hands to the point where even if I happen to be sitting, you haven't gotten the point yet, that even if for some reason I went through this whole case and somehow 100% agreed with you and said, I'm going to nullify all those orders. Why was that judge requiring a supervised visit? Even if I did all that and that happened by some minor miracle, what difference would it make if I don't longer have the authority to order anything?
Your Honor has the
also,
authority
more to the
today.
point, how would I logically nullify all of that if I don't know what's been going on the last 5 years and his predisposition to see you?
Your Honor, I have an eminently reasonable...
How do you know that this wouldn't be more disruptive at this point and harmful than positive? How do you know that?
Your Honor has blamed me for not doing the Donna's house. Now I want to do it, and you're coming up with reasons to not do it.
Because it's absurd at this point. It should have been done
It's
5
absurd.
years ago. Now I don't have the authority anymore.
You don't have the authority to order
No.
to enforce the...
No. Do I have to tell you for the 5,000th time? You're big on the law and statutes. He's going to be 18. I'm losing, in a week or two, I lose authority over him. That's why I'm upset with you. I wouldn't even be half
What
as
about
upset
October 20?
if you had waited from age 12 to age 15 or 16. I'd still be upset, but not a fraction as upset, because now it's absurd, and maybe you could have been such a positive influence, but we'll never know now. And you did it. You did it, and you'll spend the rest of your life blaming her, blaming attorneys, and blaming the system, when all you needed to do was follow a court order 5 years ago, and you probably would have had a pretty good relationship with your son, or at least it's quite likely, and you don't have the insight or the accountability to understand that.
Don't have accountability. I don't understand.
You don't
that.
understand that you did this.
I didn't do this,
You will
Your
go
Honor.
the rest of your life blaming everyone else for this possible. It could even be a tragedy that he was deprived of you
It is a
as a
tragedy,
father.
but-
And
and-
it's because, again, once more, if it doesn't sink in, you can go the rest of your life, Mr. Phillips, blaming courts, blaming the other side, blaming judges, which you have a tendency to do, not complying with orders you don't
That's
agree
unfair.
100% with. When I think
That's
all you
unfair.
needed to do was exercise the supervised visit in an appropriate fashion, which you would have if you showed up. You would have gotten a positive report. You'd probably be seeing your son every weekend. For all I know, he might even be living with you primarily by now. I don't know. You did this to yourself because the more I'm reviewing this, you just have to be right. And you don't want to, as an attorney, it's particularly upsetting that you don't want to comply with orders that you disagree with.
They're illegal.
An ounce of prevention's worth a pound of cure. In this case, a ton of cure. All you had to do is go to the facility once or twice, 3 times maybe, 5 years ago, generate a report, because I'm pretty liberal about once I get a decent report from Donna's house, in the overwhelming majority of cases, supervision is lifted, so are overnight restrictions if I get a positive report. I can't necessarily speak to whether the other judges were quite that liberal, but you did this to yourself, and you're correct. You're correct. You're absolutely correct. We agree. I am laying accountability on you on this.
Well, Your Honor, may I be
Like
heard?
an issue.
You
have the right to continue to contact him.
Can I create a record today? May I create a record?
Pardon? You
I
created
wish to say I am extremely disappointed that Your Honor should blame me for what's happened in 5 years. I am extremely disappointed. I have never been found unfit,
Okay.
never been found to have done child abuse.
I'll make this point for the 200th time. You're pretending to misunderstand. I didn't allude to any unfitness. Quite the contrary. I indicated that you could have been a very positive influence. Let's just assume you would have been. Let's assume we agree on that. I'm saying you're trying to distract from the issue that had you simply complied when he was age 12 with supervised visits, this court believes it's quite likely that any restrictions would have been lifted and you wouldn't have this ongoing problem, and that now you're asking us to do something about it. You can't catch the train once it's left the station. He's going to be 18 on November 8th. And you have a complete record. If you think that you have a complete record, because the court has vented very extensively about what I feel about this, and if you feel all of that is so wrong, you have pages and pages of what I think about it, and you have a very, very strong, if you're right on the law, you have a very strong factual appellate record, because I've told you exactly what I think. So.
Well, Your Honor, you still have the ability to order the son to go to Donna's house on Friday, October 27th.
Why is that a good idea when I have no idea what's happened the last 5 years, what he thinks, how he feels? Why is that a good idea?
Because there are no allegations of me being unfit.
We're going to do this at the 201st time. And I know you know better, but I want to make a complete record and assume that someone's in good faith when they pretend not to understand. No, you are an attorney of 31 years. You don't tell me that that a 5-year-old order was wrong. If a 5-year-old order was wrong, maybe it was. That's not the point. Maybe it was. That's not the point. The point is you do something about it 5 years ago. 5 years in the life of a child is like 20 or 30 years in the life of an adult. The difference.
I've been litigating for 5 years.
Is profound. Stop.
5 years I've been
Phillips,
litigating.
Stop pretending to misunderstand. You may disagree. You disagree with my view, but don't pretend that you don't understand it. Okay?
Well, can I finish my record here?
Yes, but I'm not ordering any visits this weekend.
I understand that you know, again, I'm very.
If he wants to go, that's great. That's great.
I want to say also, with regard to these disqualifications, Your Honor has alluded that I'm somehow shopping to find a judge who's going to agree with me. If you knew the egregious things these judges did, like Mari Parlade using an AI program and forbidding oral arguments, that's not me doing form shopping.
I'll agree with that. I'll agree maybe that phraseology was a little harsh, but I do generally believe that conceptually you think that taking another bite at the apple, maybe those recusals were justified. I'm not implying they weren't. I'm just saying I tend to think, and if I'm wrong, I'm wrong. I'll tell you exactly what I think. I think you do think this is an opportunity to take a new bite at the apple. And
Your Honor, I want to see my kid, and you keep saying that I don't like the call.
You don't. No, you don't. Being right is more important than that, because I'll make a record. You really don't, your main goal, and I'll make a finding of it. So if you're setting me up with this question, I stepped into it, and you're exactly right, and you have a great appellate record if I'm wrong. I do think you want to see your child, but I think it's much more important for you to be right. And if you really wanted to see him, and that was more important to you than being right, you would have complied with court orders 5 years ago. You don't comply with orders you don't like, and you're an attorney, and you should know better. If the supervised visitation order was that wrong, there were 5 years ago, there were rehearings, there were appellate remedies, and this is a nonsensical discussion because it's designed to help you, and you're pretending not to understand, and I'm dealing with it like you're some pro per unlicensed, and you're not. You're a skilled 31-year-old attorney. You know exactly what I'm saying, but you don't want to hear it.
Well, but you're not letting me finish. But Your Honor keeps talking about being right. It's not about being right. It's about following the Constitution. I've never been declared unfit.
Okay, we're not going to go through all that. No one had to declare you unfit. The judge made certain findings 5 years ago as to why supervised visits were necessary or beneficial at that time. If that order was wrong, it should have been dealt with 5 years ago, even if you're right and there was no reason for supervised visits, you can't come at age almost 18 and complain about this order that was in place at age 12 when you haven't seen your child since then. This is nonsense, and you know it, and
No, you're
please stop.
For 5
Okay,
years,
go
I've
ahead.
been
Go ahead.
litigating.
I
5
repeated
years.
everything
I've given
20
up.
times. Go ahead and finish your statement. You don't want to
Your
see,
Honor,
you
you-
don't want to see your child. You want to keep arguing and being right. If you wanted to see your child, you had 10 gazillion opportunities over the last 5 years since age 12.
No,
And you
I have
didn't-
not
you
had
didn't.
10
I'm making
gazillion
a
opportunities.
finding. You don't want to comply with court orders you don't agree with. You just want to be right, and you let 5 years slip through your hands, and I stand by it. If that's wrong, you have a very blunt, candid, honest view of what a court thinks, which isn't always the case. So that should be great dynamite for you. If the court's so wrong and you're so right, let's not argue it anymore. You have your remedies.
It's
Let's go from
something
there.
that just, I just see, it just seems to me like
What
Your Honor is
difference would it
biased
make?
against me.
What difference would it
You know?
make? Even if everything I just said was wrong and your whole priority for 5 years was to see your son, and I'm so wrong and there's compelling reasons why you didn't comply for 5 years and that you couldn't, even though that sounds absurd. Let's just assume everything you say is right and everything the court says is wrong. Do you get it? Even if you're 100% right and I'm 100% wrong, I can't do anything about it anymore. Show me the authority that I still have the ability, just like, because he's going to be 18, he's not going to be 18 for 9 or 10 days. That after 5 years of neglect, I can railroad through some forced visit at this time.
5 years
I'm not
of
going to do
neglect?
it. Your request has been made clear,
5
and you
years of
preserved it, and I'm
neglect?
not doing it. It's ludicrous.
There's been no neglect on my part,
Okay.
Your Honor, for you
Okay,
to
so
say
in
that
other
I
words,
don't want to.
you haven't heard one word that's happened. I've spent all this time. You haven't heard one word.
You said that I don't want to
How did the
see.
court answer that about no neglect? What did I say? 20 times. Never mind.
Your Honor,
Never
I
mind.
want to see my kid. I want
Why
to see
didn't
my
you
son.
argue no neglect 5 years ago when he was 12? Why didn't you overturn the order or attempt to at that point?
I tried to overturn
Okay.
the order. I've been to the U.S. Supreme Court to
That's fine.
overturn this.
Okay. You and I are different. If I couldn't see,
Yes.
you and I are very different. If I couldn't see my child and I had these orders and I say, these orders are dreadful. I can't believe I'm being treated like this. If I didn't have the sense to come to my senses, I hope some colleague would just say, Bill, just go to the first few visits, get a positive report, and you're done. So, whatever. Okay, Ms. Wilson, anything else from your side?
I'm not going to do
Go ahead.
No,
that.
Your
They're
Honor.
illegal orders. I'm not
Okay,
going
you
to
can
follow
go- Okay, but
illegal orders.
I'm not answering any more questions. I've answered, you don't want the information. I told you 40 times.
I
It
haven't
has
asked
nothing to
any
do with
questions.
neglect, or if it did, you could have dealt with that 5 years ago. It's about, you had a 12-year-old that you haven't seen, he's almost now 18, and it's your doing that you decided not to comply with simple orders.
I just think, Your Honor, respectfully, for you to blame me is shocking. That's all I have to say. This is, you cannot place the blame
You
on
shouldn't be too shocked. I think you probably have a 5 or 6 year history of judges taking that approach, because if you're that shocked with it, you shouldn't be, because if any of these other judges remotely saw it your way, I assume they would have lifted the supervision immediately, not made you comply with that, and restored immediate contact.
The other judges openly and notoriously violated my rights with specific intent to do so.
Okay.
And I don't know what the other judges have told you, but I
Just for the
still
record-
want to see my
Just for the
son.
record, no one told me anything, that I didn't even know about all these recusals till just now, but nice try.
I have no idea what somebody's told you or not told you.
No,
The
you
point
don't,
is
but I
that
state for the record, I don't discuss my cases with other judges. You obviously are convinced that goes on, and that's fine.
well, the fact of the matter is, Your Honor, you could still order the son. If he doesn't show up on the 27th, I won't burden Your Honor. I'll just file a separate lawsuit for damages if they don't produce the child on the 27th. Your Honor can bring the parties
No, I can't.
together. Your Honor has the last clear chance to do
I
it.
told you, I can't,
You
and I
won't?
won't, because I would have to make a myriad of findings as to why the supervision was a wrongful order at age 12 and it should be overturned. I'd have to make findings that nothing of substance has occurred in the last 6 years that would change anything, and that it's healthy and positive for the boy to see you, that the boy wants it, and that it would be no sense traumatized, and that it wouldn't be disrupted, that it's in his best interest. It's not just about your rights or mom's rights. It's primarily about what's best for him.
It is
You
about
haven't
your
told
rights.
me what's
But
best
you-
for him, so you don't care what's best. You don't care what's best for him. You just want what you want.
Your Honor, I want to see my son because I know I've read 13 Supreme Court decisions, particularly Kings versus
Okay,
Massachusetts.
Okay,
It says,
you could have read 58,000 decisions. If you haven't figured out by now that just showing up and appearing for a few supervised visits would have been 10,000 times more effective than banging your head against the wall for the next 6 years, filing this, filing that, reading this and reading that. If you haven't figured out that all you had to show everyone is their concerns about me are misplaced, and maybe there were no concerns beyond that you just needed to be reacquainted with them to some extent. I don't know. So, now, if this was a year ago, I'd still be upset and say all the things I'm doing, but I would certainly say, okay, let's try a supervised visit. But we ran out
why
of
can't
time.
we do it now?
Ran out of
But
time.
Your Honor,
Ran out of
Your
time.
Honor is
Ran out of
Can
time.
I be heard?
I handled it 20
You're-
times. If I ordered it and she doesn't appear, I have no contempt power anymore, and I'd lose.
I don't want you to. But you're misunderstanding me. I'm not asking you to do
Because if
contempt.
she doesn't appear and doesn't cooperate, I can no longer do anything about it. He's 18.
I'm not asking you to. I can just sue her in independent
Okay, so
action. I
that's what
won't
it's
burden you
about.
on.
Okay, so now we get to it. You know he's not going to be produced. You don't even want him to be produced. You prefer if he's not, so you can file all your lawsuits, right?
No, Your Honor. I'm saying
You
you're
just told me.
misunderstanding me. If you don't want to have to hear something, I could file an
It's not a
independent
matter
action. that
of
wouldn't-
not wanting to hear it. I can't hear it for the 11th time. If this was a year ago and you neglected it for 4 years, I would say, we can salvage this. We still have a year. But this is ludicrous. He's turning 18.
So is the order still in effect? It's almost like you're saying the order's not in effect anymore.
Well, in the sense that no one's interested or asking you to comply with the supervised visitation order, so in that sense, you're right. And you're also right that you can speak to him. If you know she's not gonna, that she can't or won't or he won't cooperate with production for a supervised visit, so why don't you just call him which you're entitled to do, or email or text
I've
him.
called him 65 million times.
Right.
He never answers the phone because it goes straight to voicemail because his
Okay.
mother's brainwashed.
Okay.
So we're just going to have to
let's
keep
assume you're
litigating.
right. Let's assume you're right. Then, in other words, you know he won't be produced. So it's just, and if you want to proceed with your lawsuit, I'm not going to issue an inane, unenforceable, absurd order just so you can have your lawsuit. You're going to do your lawsuit no matter
I'm
what.
not
So go ahead.
For a lawsuit. The purpose is not to do a lawsuit. If you were to tell Shannon Wilson to instruct her client to make the child make a phone call,
Okay.
let's see what happens. Your Honor can order a phone call. Why are they not making phone calls? How come Shannon Wilson won't explain why the son won't call me? She would have knowledge. She could ask her client, but she's never done
I'd be
that.
happy to
Because
explain,
Shannon
but
Wilson
I'm
wants to
not
keep
modifying the order beyond the existing order that you and can communicate with each other.
But we're not
You
communicating.
know, in fact, I
of
take
any
back
kind.
what I said when I said if it was a year before he's 18, I would be active. Actually, if it was just 6 months before he was 18, I'd do something. But this is absurd. Miss Wilson, anything, in fairness to him, anything major I'm missing about the record over the last 5 or 6 years? Please correct it.
No, Your Honor.
All right. So, Ms. Wilson, the order of today needs to be very firm that I am making the findings that, and that's why I need you to correct this chronologically. It appears to be correct for my review here, that the supervised order was put in place when he was 12. There was it wasn't complied with, and that now he's turning 18 in literally a few days, and the court believes it no longer has jurisdiction over custody / visitation, but that the order remains in place till he is of age, that dad and him can voluntarily contact each other. Beyond that, I'm not sure what orders we need. Or do we? Hello?
Yeah, I'm trying to think of any other orders that we need, and I cannot think of any, Your Honor.
So keep it simple, just, and in fairness to him, let's keep it simple. That way, be that blunt about it, because if I'm wrong, then he deserves to have the record very clear. That, yes, I'm making the fine, he's saying you're blaming me, yeah, in a sense I'm saying he is accountable for it. He is accountable that there has been supervision ordered at age 12. It was not complied with, and that now the child is turning 18 in a few days, and the court no longer has jurisdiction to order anything, and the father demanding that the court set up a supervised visit in the few days before he turns 18. Number one, seems to be motivated by his own statement of some desire to file a lawsuit for non-compliance when mom doesn't comply. Thank you. And number two, more to the point, it totally ignores everything about best interest, because the court knows supervision was put in place 5-6 years ago, and the court knows nothing about what's occurred in the child's life since then, or how he's disposed toward visiting dad or not visiting dad, beyond dad's representations that he's initiated contact and hasn't received anything back. So it would be preposterously violative of the child's best interest if the court ignores the last 5 or 6 years of no contact and automatically assumes that it's in the best interest to just force a visitation at this time, when I know absolutely nothing about how the child's dealing with all this emotionally, etc. And that'll be that, I guess. And it's really a shame. I feel as badly as Dad about this, but we have different opinions, an honest difference of opinion as to the source of some of these problems or what caused them. But it is what it is.
Well, Your Honor, I have a question, if I might. Your Honor says you have no
I've
jurisdiction.
answered every question 20 times. You don't want to hear it.
No, you haven't. When did Your Honor lose jurisdiction? You said you have no jurisdiction
about,
to
if not now, in less than 2 weeks. So, you know.
No, but do you have jurisdiction today?
I have jurisdiction until November 8th, and I've made a clear order. Why do you keep asking questions you don't like the answer? I couldn't have been any more clear. The court indicated, and it's clear to Ms. Wilson, she'll include it in the order, that the court loses jurisdiction in 2 weeks, and that it's an absurd abuse of discretion and clearly violative of the best interest of the child. In this case, when there's been no compliance with a supervised visitation order initiated when he was age 12 and no contact that I'm aware of between dad and age 12, that it would be absurd just a few days before age 18 to ignore those orders that weren't complied with 6 years ago, to ignore 5-6 years of no contact, and totally ignore or be oblivious to what's occurring emotionally with the child, or how he's predisposed toward this, and just frivolously just order a visitation at this time without any semblance of answers to any of those questions, because this is about best interest of a child, even if a party wants to frame it more about what they want or demand. It's about what's best. So I'm not doing it. No, can't do it. And you'll have no, Miss Wilson will put exactly what the court just said in those regards. So you have a great gift here, is that the court's been extremely detailed, more than most judges would be, spent a lot of time on it, was very repetitious, and was very candid about what it thinks about this case from a legal standpoint, a behavioral standpoint, you name it, an emotional lifestyle standpoint, everything. So if the court is as glaringly wrong as you are convinced it is, you have a multitude of statements on the record, which you are required to, of course, quote in context and not cherry pick out. But if you quote everything in context and you're right and I'm wrong, that's great. But the problem is now, doesn't do you any good in this case because he's outside the jurisdiction of the court. So if it's about your lawsuits or something,
He's not outside today.
Sorry.
Well, let me say this. Your Honor indicated that I'm doing this to set up some lawsuit. It just shows bias on the part of Your Honor.
That's not interpretation by the court. It's that you telegraphed that. You told us blatantly that's what's going on.
Because Your Honor didn't want to exercise jurisdiction. I said if he doesn't show up, I have no jurisdiction.
Again, this is about the lawsuit because you know or should know, for all the reasons just mentioned, that because the court didn't issue an absurd order violative, where grossly abusing my discretion, which is violative of the best interest of the child, that you wanted the court to issue those orders just on the hyper-technical argument that I still had jurisdiction for 8 or 10 days, and that somehow I should ignore everything in the last 6 years, that would be, that you asked the court to issue orders which I think are clearly violative of best interest if I don't know anything about where he's predisposed, and is a clear abuse of discretion, and that's that.
Well, it's a shame to me, Your Honor. Again, I'm extremely disheartened. After
Okay.
5 years,
Yeah.
I've had no misconduct.
Okay, and
of any
again, for the
kind.
50th time, pride comes
In a
before the
room.
fall. All you had to do is walk into that supervised visitation room 2-3 times. Your problem probably would have ended 6 years ago. It's because of
Maybe.
you wanting to pound, wanting to be right, wanting to litigate. That's why you're in the
Okay.
situation you're in. And I made that very clear, and if I'm so wrong and you're so right, which, you never know, maybe it's a case.
I believe
you have
you've
a
made-
great,
I
you have a
believe-
great record.
With all respect, Your Honor, you've made your bias very
Okay,
known
that's
to
fine.
me, and it's a shame.
That's fine.
But
I would be, I would be, I don't even, it doesn't matter.
it's a shame.
I would be happy,
It doesn't-
I would, if I have a grounds to recuse that I'm actually getting aggravated because I think a litigant has abandoned all concerns about best interest and is just concerned with being right and litigating. I would be,
May I be-
this court could recuse on its own volition. You just ran out of time. You ran out of time, so it doesn't matter who hears it.
Your Honor, the best interest resides with the fit parent. Troxel versus Granville. Your Honor, respectfully, has no jurisdiction to
I've
exercise.
made an exhaustive record, I'm very confident. Now, yeah, but it's.
I didn't finish making my record yet.
Okay.
In Troxel versus Granville, fit parents are presumed to be acting in the best interest. Under the
I
Prince
answered,
versus Matthew,
all those arguments should have been made 6 years ago, maybe you're right. But
I made them
should
for
have been
5 years. I've been making them.
Okay,
And finally, in the case of Roe versus Roe, they said it was unlawful that the mother only had 6 hours of visitation. I've never had anything. Your Honor can do something, I believe, to bring the parties together here. But it seems to me, Your Honor, is so biased against me, you won't do it.
That's fine. Bias apparently is defined by me spending an hour and a half putting myself way behind calendar because I think this is a tragedy. And I'm tried really hard, which was foolish of me, because I get accused of bias if I'm trying so hard to get you to put the focus on your son and off being right, and because there's this wall up.
You blamed me for
I
the...
already telegraphed to you what I think you should be doing, because I raised one issue which could possibly have some merit if you want to brief it. I don't know if he doesn't, neither of you know when he graduates. If he doesn't graduate till May, you may have, no one has that answer. If someone can produce that answer and say, Judge, you not just have 7 days left, you have 6 months left, and you could interview this child or do something. I already told you, telegraphed that to you, you don't care.
Graduate in May.
Pardon?
I reasonably believe he's going to graduate in May.
Okay. I'll tell you.
But I don't know the school
I'll tell
wouldn't
you what.
talk to
I'll
me.
tell you what. See, no one has to waste additional time and money. If you send proof to Chambers and CC Miss Wilson that there's no graduation till May, and you quote the authority that the court not only has jurisdiction over support, but over custody/visitation concerns till the graduation date, and if I'm persuaded by that, which could be the case. I said that could be the case. It's the only possible thing could be in operation. I'll just go ahead and set a hearing on it or issue an explanatory minute order. So that's what I think you need. That's the only thing I think that could possibly be. And I don't profess, I think I lose jurisdiction, but it's possible that since it extends till graduation, or some argue the statute technically till 19, if support purpose, but it's been interpreted as ending with graduation, the court possibly would have jurisdiction over this dispute. Because even if the court had 6 months to play with, I'd be viewing this dramatically differently than someone bringing this in 10 days before he's 18. So that's what if there's anything to focus on, that's what you should focus on, but it's up to you.
Well, am I understanding that Your Honor is allowing me an opportunity to try to learn whether or not he's going to graduate for sure in May? Because I can represent to the court, that's my reasonable belief, and I would think that Shannon Wilson should know this.
Why don't you, I don't know to what extent you have access to the school or other records, why don't you contact the, just send something, and with an attachment, CC Ms. Wilson, indicating how you ascertained that information, if there's some document, or no proof. If Miss Wilson agrees with you, then say, okay, contact Miss Wilson, I'm CCing her this letter, graduation is in May. It doesn't necessarily mean anything's going to be different necessarily, it just means at least there's a conceivable window to deal with. So that's where I'll leave it.
Your Honor,
Yes.
the decree entered in 2020 gives Mr. Phillips the ability to obtain the child's school records. So he has the direct ability to contact the child's school to get that information as you have requested.
Perfect. All right. That's where we'll leave it. So he may have some window, but no one's gonna push this court into doing something with 10 days left. It's absurd. But if there's 6 months, well, who knows? 6, 7 months. So we'll leave it at that. That concludes the hearing.
So, Your Honor.
But you have to add that to the order that he has that opportunity. So just ascertain that. Yes.
Well, and so here's what I would also like to add. If we're going to go down this most
I
interesting
didn't
path.
say we would. I just said that it's fodder for consideration if it's established. I may not receive anything. If I do, then we'll deal with it. It's probably best as a filing, not just a letter to Chambers. It's probably best as some sort of filed exhibit that he confirms is received by you in Chambers. That's fine. The letter.
Your Honor, I can faithfully avert to the court that I will do this right away, and I will contact the court right away, because I want the court to know my only interest is in seeing my son. That's it.
You may have one last opportunity to prove that that's what it's about, not being right, or filing lawsuits. So get on it like immediately, and we'll see where we're at. Ms. Wilson, this is just a possible safety valve in case there's something major going on. This doesn't mean you should be panicking about having to do tens of thousands more of free work, because I don't think I'll worry about this if I see something. But right now, no one's presented anything, so we not only need representation at graduation, but probably, and I don't profess to be too skilled or knowledgeable on this narrow point, but on account of, and child support, it's pretty clear. It says Charles Dillon School continues to 19. That's been interpreted, though, as if you graduate when you're 18 years, 3 months, you don't get the other 9 months, you get the additional 3 months of support. But I'm not aware of a case or statute, this jurisdiction or otherwise. Doesn't mean it doesn't exist, just mean I'm not aware of it, that has dealt with this narrow issue of trying to effectuate reunification on an 18-year-old who doesn't graduate for 6 or 7 months. So there may be nothing on it, or there may be. We'll worry about it if something's produced. So we need not only, number one, the information from the school, but number two, some sort of authority, statutory case-wise, of which I freely admit I'm not particularly aware. All right, thanks, everyone.